In these extraordinary times, I'd like to welcome you to the March 24th meeting of the Zoning Board of Appeals. First up, we have a request for an extension. Appeal number 2021-004, 40 Manor Lane LLC, for variances and/or relief from Chapter 301, Section 51, where a proposed lot width for Lot 1 is 122.22, and Lot 2 is 99.50, and required is 175 feet, where proposed side yard setback for Lot 2 is 28.3, and the minimum required is 30 feet. Where proposed lot size for Lot 1 is 20,746 square feet, and Lot 2 is 15,489 square feet, and the minimum required is 80,000 square feet. Where proposed impervious coverage for Lot 1 is 19%, and Lot 2 is 28.2%, and the maximum permitted is 15%. And Section 243C3, where proposed lot size for Lot 1 is 20,746 square feet, and Lot 2 is 15,489 square feet, and the minimum required is 40,000 square feet. As such, as no such lot for which subdivision is applied for shall result in a lot 1/2 or less of the area permitted in the zone. Pardon me? Okay.
What's the extension date?
Okay, so the extension is expiring 25/23.
So moved.
2/25/23, yes.
Second.
Leroy?
Yes.
Okay, so
We gotta vote here.
got your extension.
We gotta vote now.
What's that?
We have to vote.
Go ahead.
No, we have to vote.
We did.
Okay, good. Thank you.
I think all right, do it again. Otto?
Yes.
Aye. I say aye, and Leroy says
Aye.
Okay,
Aye.
take off.
Appeal 0929 Car McVeigh LLC, 370 Manor Lane, Jamesport, tax map number 6004723, APZ zoning. Public hearing pursuant to order of the Supreme Court, State of New York, dated April 2nd, 2013, that remanded the matter to the Zoning Board of Appeals for a new hearing and determination to review the letter dated April 8th, 2008, made by Richard Hanley, Planning Director, regarding the addition or use of a temporary tent on the property, and to review Planning Director Richard Hanley's letter dated January 16, 2009, regarding the applicant's second site plan application to locate a barn on the property upon the same grounds as set forth in the April 8, 2008 letter.
Who's here for the applicant? Excuse me, is it easier for you to sit down in one of these chairs with everything in front of you? The speakers are there. Why don't you do that? Thanks.
Thank you, Mr. Chair. Do you mind if I have some, Mr. Chair? I can,
We're not going to question what's in it.
okay. I may run out of voice otherwise. Before I begin, I prepared a written version of what...
What you're going to do first is state your name.
Yes, that's a good idea. My name is Linda, middle initial U, Margolin, from the firm Margolin Besunder, 3750 Express Drive South, Islandia, New York. I'm here for the applicant. I replaced Chiarelli and Dempsey. Both Mr. Chiarelli and Ms. Dempsey retired since the last time this board had...
Lucky that.
We emailed a presentation that we had prepared for the board, but I brought hard copies with me, so I would like at this point to hand up enough for everyone who's present, and I have extras if you think Mr. Barnes wants a copy.
Yeah, you might as well just leave them with
Okay.
Chris.
So I have plenty of copies. And I thank you for giving me the opportunity to sit down. I'm out of practice in standing. I've only been in court twice in the past 2 years, I think.
Well, lucky you.
I wanted to bring to this board's attention the fact that we sent a letter to the town attorney and to Mr. Barker indicating that we thought that he was conflicted from serving as this board's counsel. And I wanted to hand up the letter that we sent so that the board is aware of the issue. I have plenty of copies. Basically, the issue is that Mr. Barker, who was originally, or Smith Finkelstein, was appointed by the town attorney to serve as counsel for the zoning board in this matter.
Linda, one moment, please. I think we got the microphone cover up. This giving us
Oh,
some
I'm
feedback.
sorry.
So we just gotta keep
Excuse
to
me.
make sure that that's like,
How's that?
and
I'll move everything away. At that time, his appointment was only to serve as counsel for the zoning board of appeals. Subsequently, the town of Riverhead, who has sued my client, seeking to shut down his operations, his catering operations, appointed the firm of Smith Finkelstein to represent the town in that ongoing litigation. And since that time, Smith Finkelstein has filed papers taking a position, among other things, on exactly what this zoning board did in 2004. And for that reason, we think it's inappropriate that he serve as independent counsel for the zoning board now, because he's already taken a position for his other client. And I believe that under the rules of professional conduct, that creates a conflict, it creates circumstances that may interfere with his ability to be impartial and represent this board impartially. So the result of our letter was I was advised by Mr. Barker that he and his firm were not going to step away from representing this board. I don't know whether this board was made aware of the problem, but I'm bringing it to your attention now, and I'm prepared to proceed. So,
I don't think there's nothing to respond to, no.
let me see if I'm going to start. Okay. The issues that this application presents to the board are probably unlike the issues you've seen in any other hearing. The narrow issue that's presented by this appeal is whether Planning Director Richard Hanley was correct in refusing to let my client's site plan application go to the planning board. The two letters that Mr. Hanley issued are Exhibits J and K in what's printed here. The actual proceeding in front of this board is essentially a review of whether Mr. Hanley was correct in his letter of January 16th, 2009, but we include his earlier letter of April 8th, 2008, because he refers to it as in giving the reasons for the fact that according to this, your submission, that is your amended site plan application, cannot be considered by the planning board at this time because it contains plans for an expansion of a pre-existing non-conforming use that requires a special permit. That's what his letter in 2009 said, and his letter in April 8th, 2008 said that the existing zoning, section 108-51A, it's now part of chapter 301, but it was 108 back then. Non-conforming uses may only expand if the town board approves an expansion by a special permit. And so that was the reason he gave, and therefore my client's amended site plan was never considered by the planning board. So that is the issue. That's the narrow issue. The question essentially is, I think, a twofold question. One is, did Mr. Hanley have the power to make that determination? And the other is, if he did, was he free to disregard the determination of this board and the determination of the court case that followed this board's 2004 determination, which addressed the issue of catering as an accessory use in a separate facility to be erected on my client's property. So what is at stake here in this hearing, I think, are two things. One is the integrity of this board, and the other is my client's ability to have a viable business. Because of Mr. Hanley's decision so far, my client has been unable to proceed with getting site plan approval to put up a building so that catered events can be held indoors. I'm sure I don't have to tell you that restaurant owners like my client have had a particularly difficult time over the past couple of years. In the town of Riverhead, I think changed their rules at least temporarily, allowing outdoor dining, but that was only temporary. My client has been holding catered events in a tent on this property in recent years. These are essentially outdoor events because the tent is not indoors, but this is not a viable long-term solution. The town has sued to stop him, and it's also very difficult for my client to make sure that these events adhere to the noise limits in the town code when they're being conducted in a tent. He needs a building in order to make sure that he can adhere to the noise levels in the town code, and that's one of the reasons that this hearing is so important to my client. These issues were already teed up for a hearing in 2009. I wasn't the applicant's attorney at the time. I think that Mr. Whitmire was on the board at that time. I don't think either of you were.
I was.
You
I
were?
wasn't.
Okay. What apparently happened, according to the records in the court case, because there was an Article 78, is that the hearing was adjourned several times after an initial hearing, and on a certain date, when my client's then counsel had requested another adjournment, the board refused to adjourn it, proceeded with the hearing, and then dismissed the appeal because the hearing that night had not been reposted by the applicant. Your town code requires posting at each time, and we do have an affidavit of posting with us, and we will file it with you. If you like, we can do that right now.
Could you speak up a little bit?
She just wants to file her
Would you like us to
affidavit.
file the affidavit of posting?
Yes,
right now?
please.
Okay.
And you also need to speak up a little bit on the camera.
Okay, I will try and do that.
Thank you.
Okay. We previously filed the affidavit of mailing. So after the ZBA dismissed the application, there was a court suit brought to challenge the dismissal of the application. For reasons that seem difficult to explain, although the court suit was brought in 2009, it wasn't actually decided until 2013. And in 2013, Justice Farnetti issued an order that said that most of the claims being made were premature, and he was sending it back to the ZBA to hold a hearing on the application that had been dismissed. I have no knowledge as to why the hearing never got scheduled between 2013 and 2021. I do know that I was contacted in the summer of 2021 by my client saying that the town attorney had reached out about holding this hearing that was ordered by the judge in 2013. And that was last summer. By then, Mr. Chiarelli and Ms. Dempsey were long retired. The client had to find a new lawyer. He found me. Mr. Chiarelli no longer had any files. He'd thrown them out long ago. It took us some time to reconstruct all the files that bore in this case. And between that and some scheduling issues, that's how we wound up in front of you today. The written submission that we've prepared, we've done that because there's so much history here. And the history is essentially, I'll call it the legal history. I don't intend to recap all of that in my presentation to you. We make the written submission so that we could keep this presentation to a reasonable length. But I will tell you that while my job is to represent the applicant, I have an obligation to be accurate and truthful in what I tell this board, and everything I tell you can be backed up with the documents that are in our written submission. Before I get to the history, I just want to digress for a moment and make clear what my client's dilemma is. Jamesport Manor Inn is a historic building. I assume many of you are familiar with it. It was used as a restaurant in the past. The property was purchased by Carr McVeigh in 2004, and at that time, they went to the zoning board to see if the restaurant use had lapsed, the non-conforming use had lapsed, or whether it was still viable, and to see if they could get the approvals necessary to also conduct catering on the property. The previous owner of the property, I think in 1998, had gotten a use variance from the Zoning Board of Appeals to ditch the restaurant use and instead put a motel with a swimming pool and tennis courts on the property. But that wasn't Carr McVeigh's plan for the property, and so they came to the zoning board and asked essentially for a use variance or a modification of the prior approval or whatever else they needed in order to be able to do, to renovate the Jamesport Manor Inn, to make it into a restaurant again, and to have catering in a separate facility. And what I wanted to point out to you is Exhibit A, the very first exhibit in our packet, is the conceptual site plan that was submitted to the Zoning Board of Appeals in 2004 as part of that application. And you'll see that it has the historic building labeled Manor, and then it has a tent area, and at the back of the property it has something labeled a barn. That was explained to the board back in 2004 as being a rustic style building from its exterior, so it would look appropriate in the area, and that would be the venue for catered events, together with parking and other improvements. So that was what was in front of the zoning board in 2004. This board in 2004...
Excuse me one second. I apologize, I didn't turn this thing on.
That's okay, but you're reminding me to turn off my phone.
Thank you. Continue, please.
This board decided in 2004 that they would grant my client the relief that it was seeking. My client had made the point to the board at the time that the Jamesport Manor in itself, the historic building, was not feasible to be used for catering. It has a lot of small rooms, it didn't hold enough people. I know in testimony that was presented to this board in 2009, Carr McVeigh explained that for catered events, people are typically looking for a venue that will hold 150 people. It's not, you can't really run a catering business if you can't accommodate that many people. So the Zoning Board of Appeals gave my client the approval that he needed in order to have a catering business in a separate facility. And that was important to my client because it was part of their business plan. It was what made sense of the acquisition of the property. Of course, we're here today, and they have not yet been able to erect the catering facility that this board allowed in 2004. I wasn't there in 2004, but I'm told that it was a very contentious public hearing. That's what the former town attorney, Mr. Kazakevich, told me. He said there were a lot of people in attendance, and I don't know, how the numbers stacked up, but there were people who spoke vehemently in favor of reviving the restaurant in this historic building, and there were also people who were very much opposed. At the end of the day, the Zoning Board of Appeals issued its decision. We've included it in here. That's Exhibit B. And it references catering in a separate facility, finds that catering is an accessory use. And because this was the APZ zone, a zone that had been adopted, I believe, while the application was pending, because Riverhead basically overhauled its town code in 2004. Unlike other zoning districts in the town, accessory uses in the APZ zone do not have to be subordinate. I think there's a reason for that, by the way, because in the large properties that were zoned APZ, it was typical to have more than one use, and you could have a farm, you could have a residence, you could have other things. It didn't require that one use be predominant and another use be subordinate. As long as they were accessory uses that is customarily incidental to the principal use, they were okay. So the Zoning Board of Appeals found that catering was a customary incidental use to a restaurant use, and it found that it was appropriate for a separate facility. And it did so at a time that the law on the books to which Mr. Hanley referred, it was on the books then. That is to say, the law that said that a pre-existing non-conforming use, it says, may be expanded by special permit from the town board. Doesn't say expansion is prohibited, it says may be expanded by special permit from the town board. So I don't know exactly what the ZBA's reasoning was back then, whether it was that they were interpreting that code section to say it could be expanded in more than one way, whether they were interpreting what they were presented with to say this is not an expansion. There's a lot of case law in New York that says that a more intense use of a property that's already dedicated to a certain use is not an expansion, is not an extension. But that's what the Zoning Board of Appeals did. So when Mr. Hanley, well, I'm gonna go out of, I'm not gonna take. So what happened after that Zoning Board of Appeals decision? A number of the people who had shown up at the Zoning Board of Appeals hearing to object to the application that was being made brought an Article 78 proceeding to challenge the Zoning Board of Appeals decision. And that case was litigated in front of Justice Cohallen for 3 years. We went back and reviewed the entire file in the county clerk's office of that litigation, which is called Barbado against the Zoning Board of Appeals. And we went back and reviewed it because we wanted to see what had actually been litigated in that case. There aren't memos of law explaining the legal arguments that the parties advanced. I think that's because Justice Cohallen's custom was to take oral argument on every application that was in front of him. I know I appeared in front of him a lot of times, and that's what he did. And the transcript of that oral argument is not present in the file, so we don't know what was said. But we do know what the petitioners there alleged, and we do know the position that the Zoning Board of Appeals took in that litigation. And this is one of the reasons that I've given you a copy of the petition in this assemblage. And what's particularly important in this petition is paragraph 65. And paragraph 65 says, it's got a bunch of subparts. It says, the determination, this is on page 14 of Exhibit C. It says the determination is illegal, arbitrary, and capricious, unreasonable, and made in violation of lawful procedure and statute for various reasons, including but not limited to. It says A, the catering facility, which is to be located in new buildings and structures to be constructed on the property, is an unlawful expansion of a non-permitted or non-conforming use of a property where only one building had previously been used for a restaurant. Then it says the board's determination that the property lawfully could be used for catering in the new building and structures is illegal, arbitrary, and capricious, unreasonable, and made in violation of lawful procedures. And then it says this determination was made without substantial evidence to support the findings and conclusions. The Zoning Board of Appeals put an answer in, and the answer denied each and every allegation in a variety of paragraphs, including this one. What exactly did the petitioners mean when they made this allegation? What you can see is that in Exhibit E, which is an order to show cause that was also filed in this case, there's a supporting affirmation from the attorney for the petitioners. And here, they're a lot more specific about what they meant. And that's in Exhibit E. And it says, and I'm sorry, it's taking me a
Page.
little while to find it. Did I say E? That's
You did say
That's wrong. I apologize. It's, because that's mislabeled here. And if I do, okay, I'm sorry, it is D. So if you turn it to Exhibit D, there's an affirmation of an attorney, and what it says, I'm sorry, I don't have that. It says quite specifically on page 14,
You're in D
You
now,
still
as
on
in
D?
David?
what?
You're in section D as in David?
It's E.
I am in section,
In my copy, the order
It's
to show
E.
cause and information.
so I'm sorry,
It's E.
these appear to be
E?
it's E in mine, too.
Okay,
I'm not
reading
good
the
at letters,
14
apparently.
pages in the last one.
It quite specifically says that you can't do this. The Zoning Board of Appeals couldn't do this because a special permit was required from the town board. Now, that's the same issue that Mr. Hanley raised when he refused to let the site plan application go forward to the planning board. It's exactly the same issue. So, and that law, well, let me back up. That law's been on the books for a long time. That exact wording about expansion of a special permit by special permit from of a non-conforming use by special permit by the town board has been in the town code of the town of Riverhead since 1975. It has had a slight change in language in recent years to exempt certain residential applications, but otherwise, it's been exactly the same. And as I said, it doesn't prohibit the expansion of non-conforming uses. It says they may be expanded by special permit from the town board. Lawyers who deal with interpreting the zoning code will tell you, because the courts have told us, that zoning codes are in derogation of individual property rights, and therefore, if there's an ambiguity in a zoning code, you interpret it against the municipality and in favor of the property owner. So I think there isn't any question that the way the town code is written with respect to town board approval of expansion of special permit uses, it can't be the exclusive method of expanding or extending non-conforming uses, because it doesn't say so.
I gotta ask a question here.
Yes, sir.
This stuff is all overwhelming. I mean, this is like, my God, a book
Speak up,
report. It's like a book report. But you keep talking about the special permit and this and that. 2007, there was a special permit granted. What happened?
Oh, well, I'm happy to speak to that. Let me speak to that. The litigation that followed this board's determination in 2004 took 3 years. And at a certain point, my client made an effort, even though they didn't believe they needed the special permit from the town board. They went ahead and proceeded to make an application for a special permit to the town board. The town board special permit that was issued was not what my client was looking for. It was engrafted with a lot of conditions, and it was in any event conditional upon the outcome of the litigation that was then pending before Judge Cohallen. So the town board gave my client a special permit they did not give them what they wanted. They engrafted it with a lot of conditions that were not acceptable, and it was subject to the litigation which was ongoing. So my client never took advantage of that special permit. But they had gone ahead and applied for it because they didn't know how the litigation was going to turn out. Does that,
It's not quite clear, but I'm with you.
okay. So it was a contingency plan, I guess. I don't think, based on the conditions that the town board engrafted and the very limited relief that they gave, I don't think my client could have availed themselves of that special permit in any event, even if the litigation had not turned out in front of Judge Cohallen the way they hoped, but they never had to face that issue. So this was litigated in front of Judge Cohallen. And as I said, we don't know what legal arguments were made by counsel for the zoning board, but we do know in the answer they said that the entire petition ought to be dismissed. In other words, as far as counsel for the zoning board was concerned, none of the allegations in the petition were meritorious. The zoning board of appeals decision was correct. And so Justice Cohallen ultimately issued his decision in 2007, and we've given that to you also. And his decision, which I hope is Exhibit G, because that's what my
Yes, it is.
table of contents says, okay.
Yes, it is.
And this decision, and I just want to draw some language in it to your attention. It's pretty far towards the back. Some of it's already highlighted, and other of it I wanted to point out to you. So on page number 3 of his decision, at the very bottom, he says, the ZBA's determination that the permitted pre-existing non-conforming restaurant use would not exclude catering is reasonable under the circumstances, since catering is neither included nor excluded and does not require a separate special permit. And then further down on page 4, in the middle of the last paragraph, Judge Cohallen says, the determination by the ZBA in a well-reasoned opinion dated October 14th, 2004, found that the standards set forth in the Town of Riverhead Town Code were proper and that the respondent's application merely sought the continuation of a permitted use, i.e. a restaurant with the added dimension of catering facilities on site in place of the prior added use of motel and accessory uses. And then on the last page, page 5, he said, based on the entire record before it, the ZBA could rationally conclude the proposed pre-existing and permitted non-conforming use as a restaurant, along with catering facilities as set forth in the respondent's application, was proper, and its determination granting the requested relief by the respondent, Carr McVeigh, was not arbitrary or capricious. Accordingly, the petition is denied and the proceeding dismissed. This was exactly the relief that the Zoning Board of Appeals Council asked for at the time. Deny the petition, dismiss the proceeding, and uphold the ZBA determination. So that's what happened between 2004 and 2007. So after that decision was rendered in 2007 and no one appealed, it was final. My client's site plan engineers and surveyors put together a site plan. Now it wasn't a conceptual site plan anymore, it was an actual fully engineered site plan as required by the town code, and filed it with the planning board. I think they then amended it, but between the original submission and the amendment, Mr. Hanley sent a letter saying, essentially, this isn't going to the planning board, it stops right here at my desk and I'm rejecting it. Those are the letters we referred to earlier. And then after they amended the site plan application, he did exactly the same thing. So I could speculate on why he did it. I remember when he retired, he's not here anymore. I don't know whether he did it at the direction of some elected official, because the losers in the Article 78 were unhappy. I really can't say, but the question before you is whether what he did was correct. And that comes before you, it's kind of an anomalous situation. Mr. Hanley was also a code enforcement official. And determinations by code enforcement officials are appealable to the Zoning Board of Appeals. Because they're appealable to the Zoning Board of Appeals, no one could litigate directly about whether or not Mr. Hanley's determination was correct. They had to exhaust the appeal before this board first. So there are two issues, I think, with respect to Mr. Hanley's actions. One is procedural and one is on the merits. I'm going to talk about the procedural issue first. That is, was he entitled to reject the application to the planning board? The existing law at that time, which is a little different from the way the code reads now, was section 108-131. It was adopted by local law 23 of 2002, and that's what was in effect in 2009. And subsection B2 of that law, and I'm sorry it's not in my materials, but I'll be happy to furnish it to the board after the close of the hearing. It says that the planning department shall reject any application if it is not so complete or in conformance, and shall notify the applicant for the reason for such rejection, referring to the portions of the code at that time that indicated what was supposed to be in a site plan application. It's pretty clear that Mr. Hanley didn't reject this application because it was incomplete. And I personally don't believe that he had the power to reject it for any other reason. But the other alternative is to consider the merits of what he had to say. And he said, the planning board can't consider this because you need a special permit from the town board. As I pointed out, that's exactly the issue that the Zoning Board of Appeals litigated in front of Justice Cohalan. That's exactly the issue that Justice Cohalan disposed of by finding it was not meritorious. He didn't grant the petition for that reason. So at this point, there are a bunch of legal doctrines that we think apply. And I'm sorry that we're arguing this like a court case, but that's what it looks like to me.
Sorry.
There's the doctrine of administrative res judicata that I know this board is familiar with. That is, if you made a decision about something earlier and you're presented with the same situation, you should decide, you should adhere to your prior decision. It usually comes up when someone reapplies for something they got denied before, and now they show up 2 years later and they're making the same application. Sometimes it shows up as when someone says, my situation is just like so-and-so 3 years ago to whom you gave a variance, and therefore you should give me a variance. But that's essentially a doctrine that says that zoning boards should value administrative consistency in their decisions. In this particular case, you already decided the issue of whether a town board special permit was required, because you said no special permit was required. The other two legal doctrines apply because there was a court case. And these two doctrines are res judicata with respect to court decisions and something called judicial estoppel. Res judicata with respect to court decisions says that if I litigated a matter to conclusion, then every issue that was raised in that litigation or could have been raised in that litigation is final and disposed of, and you can't relitigate it. That's one, and I'm sure you're fairly familiar with that. The doctrine of judicial estoppel is a little bit different. It says that if a litigant advanced a particular contention or fact and in a piece of litigation and they prevailed, they can't be heard to contradict that in the future. In other words, if you advanced a proposition and that was the basis for the court giving you a victory, you can't change your mind later. So we believe, based on everything that happened here, that this board is obliged to find that Mr. Hanley's letters were wrong and that no special permit from the town board is required, and that he was wrong to reject the site plan application that should have proceeded to the planning board. I say to you, I don't usually come before boards and tell them this is something they have to do. I'm generally appearing before boards, asking them to exercise their discretion in my client's favor. But I truly believe that the board possesses no discretion in this particular matter. You already decided the issue. You already litigated the issue. It's over and done with. And whether you personally believe that the way the board decided in 2004 and the way the case was litigated between 2004 and 2007 was right or wrong just doesn't matter. But I will say that I think the Zoning Board of Appeals made the right decision in 2004. They weighed the issues. They heard people's concerns about the possibility of noise and traffic. The catering was supposed to be an enclosed facility. I don't think that anyone considered that it was going to wind up in a tent because they could never get to the planning board for site plan approval. So I think the zoning board made the right decision, but it doesn't even matter what I think. I think that since that was the case, since it was done, since it was litigated, since it was upheld by the courts, since the petitioner's reasons for setting it aside included the requirement that a special permit had to be obtained by a town board, those issues are, they are now, can't be relitigated. It's done. So, in closing, I would like to say that my client is eager to move forward with a site plan application. They want to do so. They've been stymied from doing so. I believe that some of the neighbors' concerns, because I know there are people here who want to speak and I know they're concerned, some of the neighbors' concerns will clearly be able to be addressed by the planning board when it considers the site plan application. And some of the other concerns about noise and outdoor events will clearly be addressed when my client's able to put a building and have the catering indoors. That's all they've ever wanted to do. And I sincerely hope that you will arrive at a decision that lets them proceed. I'm happy to answer any questions.
We read the direction of Justice Fornetti, a subsequent decision, correct? We read the direction of Justice Fornetti, not a subsequent.
Yes, would you like me to explain that?
No, I understand this stuff, unfortunately. But the issues of collateral estoppel and res judicata, none of it was done on motion to reargue, motion to renew, there's no appeal, anything like that.
On Farnetti?
Yeah,
Nothing.
do you know why? If you're saying it's back, it was back, this has been resolved already by collateral estoppel, res judicata. There was not a motion to reargue, to renew?
I can't say, I wasn't the counsel at the time.
Well, so as far as you know, there wasn't.
I can tell you that I've reviewed the procedural history of the action, and when Judge Farnetti dismissed all of the claims as premature, except the one that required a remand to the ZBA, I can't, that was the end of it. I can't tell you.
That's what I'm asking,
how
you
it
don't know.
came to-
You don't know, you don't know.
I just want to make this clear, because you're going to see my name if you look at the judgment. At some point, and I don't remember why, I was asked by Chiarelli and Dempsey to enter the judgment on Justice Farnetti's decision.
Right.
And I did so, but
And there was no appeal of his decision?
there was no appeal.
Okay.
Anybody have any further questions for Ms. Martin?
I'm good.
I thank you for your patience.
You know, you can stay right there, if you want,
Okay.
so you don't have to be moving
Oh,
your stuff
but I
all
don't want
around.
to be in the way of people who want to speak.
Which was-
Take McMurphy, Jefferson. I think you're better off with the up top. And if you kindly raise your right hand, do you swear to tell the truth, nothing but the truth, so help you God?
I do.
Please state your name and your address.
Jefferson Murphy, 200 Howell Avenue, Town of Riverhead.
You have the floor.
Good evening, Mr. Chairman, members of the board. For the record, my name is Jefferson Murphy. I am the town planning and building administrator. I've been employed as a planner by the Town of Riverhead since 2012. I have a bachelor's degree in geography from the University of Miami. I have a master's degree in city planning from Rutgers State University. I am a nationally certified planner through the American Institute of Certified Planning since 1993. I am a New York State Certified Code Enforcement Officer. I have more than 17 years' experience as a planning board member in the village of North Haven. I am past director of the Long Island section of the New York Metro chapter of the American Planning Association, and I have more than 40 years' experience working as a planner in California, Nevada, New Jersey, and New York. With reference to this appeal before the board, I have reviewed my predecessor, Rick Hanley's letter dated April 8, 2008, and January 16, 2009. I have also reviewed the relevant code provisions in the prior zoning board of appeals decision for this property dated October 14, 2004. The subject property is zone APZ, Agricultural Preservation Zone. The applicant owns and operates a restaurant at this property. A restaurant use is not a permitted use in the APZ zone, but the current restaurant on this property is a pre-existing non-conforming use. The site plan of the applicant included an addition or a use of a temporary tent. Under our town code, a temporary tent would be considered an additional structure. Adding an additional structure on this property would constitute an expansion of the non-conforming restaurant use. Pursuant to our town code, formerly section 108-51A, and currently section 301-22, a non-conforming use may only be expanded or extended on the same lot by a special permit by the town board. For these reasons, I concur with the conclusion reached by Mr. Hanley in his April 8, 2008 letter, where he indicated the applicant's submission for site plan approval could not be considered by the planning board unless the town board approved a special permit. For the same reasons, I concur with the conclusion reached by Mr. Hanley in his letter dated January 16, 2009. The applicant's second site plan application sought to locate a barn on the property. An additional structure, in this instance, a barn, would also expand the pre-existing non-conforming restaurant use of the property. Based upon my review of the relevant documents and the town code, Mr. Hanley was correct in indicating that the planning board could not consider the application at that time because the expansion of the pre-existing non-conforming use would require a special permit be approved by the town board.
Oh, that's it.
Thank you.
Okay, so here's what we're going to do. We're going to ask those folks that are in favor of this, step up first, and we'll hear you. What? Wait a minute. What?
They're gonna, oh, go ahead.
Yeah, because we have to hear from the public, so. Anyone in favor?
We
Okay.
have not asked anyone to attend.
Pardon me?
We've not asked anyone to attend because we don't
Okay,
believe that's
well-
the issue. Yes, I just want to
Okay,
make
okay.
it clear.
If anyone wants to add anything that's new to what Linda, if I may call you that, said.
Certainly.
That's fine. We know about everything else, and we've heard the people at the last zoning board meetings that attended a number of years ago. So those aren't the issues right now. It's the letters that were written.
Well, one other thing too. If you're going to come up, fine, we're going to take your name, your address, and if you're in disagreement, fine. But don't be reciting what the guy in front of you or the gal in front of you have just said. This could go on all night long, and it's not necessary. We understand your disapproval of what they'd like to do, and we'll certainly make due note of it. But to be repeating over and over again what other people's concerns are, we understand. Okay? All right with you, counsel?
Sure.
Okay.
Just remember,
So-
as Ms. Morgan indicated, the issue here is very narrow.
Right, we
So we
understand.
would like to keep the comments narrow to the relevant issue.
So, young ladies, would you like to be first up?
Does anybody wish to be heard?
Oh, you're not with this?
Does anybody wish to be heard on this?
We have four other cases.
Sir?
John? Well, you should have brought some popcorn. It is, no?
My name is John Sapal. I reside at 81 Jessup Avenue, Walk, New York.
Great. Do you swear to tell the truth, nothing but the truth, so help you God?
I do.
Thank you, John.
So this is, of course, in opposition to this proposal. And I would like to thank the ZBA for allowing me the opportunity to talk. In regard to the appeal of 0929, a catering hall at 370 Manor Lane, please allow me to assure the surrounding community that this approval would be nothing short of a major disruption to the quality of life in and around and at great distance as well. And I apologize if I know the board does not like to be labored about emotional reading and that kind of stuff, so I'm trying to be as much to the point as possible. Yes, in the past I have supported what Matt was doing. I could go on and on for a long time too about the history of the Manor Inn. Been on the property right next to it since 1972. I was 11 when my father bought the farm next to it. For those of you who don't know, I own all the land around it, on the southern property line, on the eastern property line, and on the northern property line, as well as, yeah, he was probably there too, as well as 3 houses to the north. And I had when my father passed away in 2000, I had inherited a 45-lot subdivision on the property, which I traded for what I have now, which is a minor subdivision with not only the 3 houses, but 5 additional building lots, which will at some point be built in the future. and sold as farmettes. It's a layout that I cooked up with a great person who's not here in this town anymore, Bob Kozakovich. He helped me come up with this idea. Since then, this has turned into a full-blown wedding catering hall operation and has taken off and is now, for the last 3 or 4 years, developed a book calendar, usually holding events Friday, Saturday, Sunday. I'm told as many as 88 events were held last year. These catering hall events begin in May and go right through to November. The biggest problem is the noise. These wedding ceremonies and then later wedding receptions require the use of amplification of music that is played mostly by disc jockeys, as well as the often multiple speeches of countless members of the wedding party, which includes some jokes, some embarrassing stories, as well as a few profanities. This music is so loud that 2 people standing on my side of the fence would find it difficult to converse. As some of you may know, I said this already, I own all the property around it. This includes rears as well as. After the disastrous fire of the original Manor Inn, Matt rebuilt the building, did a great job, and I applauded him for it. And I was one of the people who spoke at the meetings in, I believe, 2004 that the attorney referred to, in favor at the time. The tented catering hall is now the focus and cash cow for the entire operation, complete with multiple tents, tented walkways to lead customers from cocktail hour to the reception tent, a Sealand container for storage, a high-end luxury portable lavatory to accommodate all the needs of a commercial wedding. Matt's agenda is abundantly clear and self-stated. To paraphrase, if I can't get what I want, I will continue to do what I am doing now until everyone gets tired of the noise. That way the town will have no choice but to give me what I want. Matt's history is to argue continually along the way while changing talking points, going back to when he rebuilt the Manor Inn, insisting that he be recognized for that. He repeats this, how great he has been for the local economy, and he is. He's charitable and community-minded. He points out farmers make noise as well. I'm a farmer. None of this is justification for the approval to build a structure that will not serve the needs of the clientele that a wedding venue brings in. These people want so-called outdoor weddings. It's a new phenomenon in the wedding industry. No one believes that the same business model will suddenly be switched and couples getting married will now be satisfied to be limited to an indoor event in an air-conditioned, soundproof walls and with doors closed when the weather is outside is gorgeous. Who wants to be, I see these people now as they come around and they're walking around. They're starry-eyed. They see what resembles an outdoor garden type of a wedding at a luxury estate. Who wouldn't want that in contrast to the catering hall at Leonard's or the Walkfield Manor or something like that? This is a great change up from what Matt has to offer. Matt's property sits smack in the middle of the largest Phase 1 and Phase 2 expanse of DRS land anywhere on Long Island. The result of all of us who farmed on Manor Lane feeling it was the right thing to do. The structure will simply serve as a prop of sorts, a small consolation in the bigger scheme. Doors will be open, tents will be hastily put up, and attendees will still be celebrating the events outdoors. The noise will continue to be a major issue, with the only difference being that Matt will then say, I spent the money and built the building for which I now have permitted use. So now everybody can just stop complaining. Wineries and breweries don't have the noise issue to this magnitude. Weddings, graduations, birthdays are always accompanied by loud music, more so today than ever before. Doesn't shut down till 10 o'clock. After that time, the noise from people trying to find their cars continues for another hour, with people clicking their fobs with the beep beep of horns, continues well past, as other neighbors that are here can attest.
Yes,
So why should we give up the quiet of Meadow Lane that existed for so long? Why should we be forced over and over and now invite it to hear over and over? I now invite Stephanie's parents to the dance floor. That's what you hear. You can hear that a long distance away. That's the microphone of the DJ. And you can hear that as far away as Herrick's Lane. Clearly, because the sound carries in our area. There's nothing to stop the noise. We should not have to suffer from the massive wattage and sound system. No one cares that your handheld decibel meter that you probably bought from Amazon says you're under the limit. Your noise keeps the people who live in the houses near and far awake when they would prefer to be asleep. I say no weddings, I say no graduations, no birthdays, no amplifiers. I'd be happy to answer any questions.
Hey, John, well, I was just going to cut you off. Listen, you have to stick with the issues that are being raised and not the sideline stuff. This is about,
I understand.
okay, so,
I understand. My contention is just that this will not be used as building a building will not solve the noise issue. And I think that is a concern.
okay, thank you, John.
Thanks.
This is for, hold on now, Matt. Wait your turn.
Okay.
Anyone else in opposition, please step up.
not in opposition.
What?
This is not about opposition.
Oh.
We're talking about the legality of Hanley's letter.
And if you raise your right hand, you swear to tell the truth, nothing but the truth, so help you God.
I swear to tell the whole truth and nothing but the truth, so help me God.
Well, you start off with your name and address.
Robert A. Skinner. My wife and I live at 14 Eileen Circle, Jamesport. Our house, according to Google Earth, is 0.55 miles from the applicant property. I'm the person who on February 16th emailed you the list, the roster of 19 individual evening events, assuming you have this. So I am not going to bother with this again because you do have it, but I will be referring to it in bulk. I want to support everything from a technical standpoint that Mr. Safala just said, because at a half a mile away, I hear what he described, at a half a mile away.
With all
Now-
respect, I beg your pardon. The issue before us is more of a legal issue as far as whether they
Okay.
should get the special
All right.
permit or not.
From the October 14th letter, 2004, Carmack Bay Zoning Board of Appeals. The definitions, and it goes on, any form of tavern, bar, nightclub, or similar entertainment event is specifically excluded. I used to go to Bordy Barn back in the day, okay? This is like Bordy Barn Light, what I hear at my house on 19 individual events. We have had other people contact both this board and the town board regarding this. If all we're gonna do is look at whether or not there's going to be an approval application for this, then here's what I say. If you allow a tent, as you have a temporary tent now, if you allow a tent, and this is what we read in the letter, a temporary tent, as I hear Mr. Murphy talk, okay, this is what these letters are about. I was cautioned that it was not about the noise, it's about the procedure, okay?
That's correct.
I've gone through this procedure. Thank you to you guys for bringing this to my attention, and I now have a better understanding. But the bottom line to this is you can't separate it. If you allow a temporary tent, this is what you will be shackling our neighborhood to, okay? And therefore, if you don't allow the tent, okay? I don't know how you can possibly not see that there's a cause and effect. If ever there was past performances indicated of future results, this is what it is. Look at there's an internet thing that somebody sent to me for Diamond Estate, okay? It's got a tent. Like it's already ready to go, it's got a tent. If you look at Google from the past Jamesport Manor over the year, it's got tents. It's got a beautiful vista. I'm going to refer to what is going to happen. There was a recent Riverhead News review that was saying that before it was Diamond Estates, Chris Carr, who took over from the restaurant from his father, Matt, last February, okay, we were told by Matt Carr that their facility was fully permitted to operate to the levels that they are, okay? So Chris, who took over from Matt last February, and then in subsequent paragraph, outdoor dining will also be a focus. We have this beautiful view of the horse farm. Between that and the land surrounding us, you're eating outside in pristine countryside. The pristine countryside is being bombarded with this noise, what we've both described. And if you allow a tent to go up there, that's what we're going to be shackled with. We don't want to hear, "I can't hear you," from a half a mile away anymore. Please, do not approve this and then shackle our neighborhood a half a mile away to what this represents.
Thank you. Thank you, Mr.
Thank
Skip.
you.
Thank
Any
you.
questions?
No, not for me.
You swear to tell the truth, nothing but the truth, so help you God?
I do.
State your name and your address.
Phil Barbado, Manor Lane.
You can leave your hat off or put it on.
Okay,
Either way.
I didn't know if that was appropriate. Yes, I've been on Manor Lane now for about 22 years, and I operate an organic farm there on 14 beautiful acres of preserved farmland. One of the things, one of the people who make that area looking beautiful so that beautiful parties can be held in the middle of it. I'm so glad that the current planning director supports the letters written by the previous planning director, and I'm glad to hear that today. I think that is primarily what this particular hearing is all about, and I totally support it. I think that that's where we have to go, and I hope that you all put another stamp on that and agree that those letters were correct and that you support it as well. Thank you.
Thank you, Phil. That's the shortest time you've ever been up to the speaker. You condensed everything and you got your point across.
I've been working on it.
Thank you. Young lady, if you just raise your right hand, do you swear to tell the truth, nothing but the truth, so help you God?
I do.
And state your name and address, and I'm glad you pulled the microphone down.
My name is Bonnie Schmidt, live at 430 Manor Lane, Jamesport. I understand that you want to get right to the point, but I just feel as a close neighbor who's been living with this, that I have something to say. My husband and I have been living and farming in Jamesport for over 40 years. Our backyard is approximately 500 feet from the tent used for outdoor events, weddings at Jamesport Manor Inn. We are opposed to catered events being held at this location. It is detrimental to our quality of life and our health to be subjected to the continuous and unreasonable noise of DJs, crowds of people, and the amplified outdoor bass music. Several requests on our part to have owner Matt Carr walk over during an event so we could hear what we were experiencing were declined. The Riverhead Code Enforcement Officer has been to our home documenting the excessive noise levels. Why are residents being forced to endure 2 to 3 events being held weekly in a non-conforming agricultural protection zone? We are unable to escape this nuisance even when inside our home. All Riverhead residents could be subjected to this type of nuisance if restaurants follow in the footsteps of Jamesport Manor. Why should homeowners be forced to call the police and take them away from urgent calls, only to have the noise turned down as the police come down the road and stay down until the police leave the premises? In addition, the Riverhead PD has indicated to us that they are unable to enforce anything to alleviate the problem. A non-functioning and non-enforceable noise ordinance is not going to resolve the problem. Issuing a tent permit in this agricultural protection zone is only setting up nearby residents for another season of unreasonable noise, calls to police and town enforcement, all disruptions in our lives, while Matt Carr continues to have his catered events, weddings, enduring no sanctions or disruptions to his business. This has become a community nuisance. The owner, Matt Carr, has demonstrated in words and actions that he has total disregard for his neighbors. Based upon postings on social media by Chris Carr in the fall of 2021, the restaurant has been sold to him by his father, Matt Carr, and renamed the Diamond Estate. Matt Carr will continue to separately operate the event catering in a non-conforming use in this agricultural protection zone. We will now have 2 separate businesses operating on the premises. In closing, I'm asking the town, please consider the residents in this area and don't let us have to endure this nuisance again this season by issuing a tent permit. Should the tent be put up without a permit, what action will the town be able to take? Thank you for your time.
Thank you.
Thank you, Bonnie.
All right, anyone else in opposition would like to speak, please step up. Do you swear to tell the truth, nothing but the truth, so help you God?
I do.
Kindly state your name and your address.
I'm Dr. Gary Rosenbaum. I live at 282 Manor Lane.
Right on the corner?
What's that?
Right on the corner, is that yours?
No, 282 is, it's sort of between the Terra Vitae Vineyard and the Manor Inn.
Okay.
I've been in the area on Manor Lane for 31 years, and the noise of this non-conforming use penetrates into my bedroom. I'm a physician, infectious disease specialist at Peconic Bay Medical Center. I'm the main COVID doctor for the entire region. And coming home after a hard day in the hospital or my office and having to hear this every weekend during the summer is very upsetting. That's all I have to say.
Well, Doc, thanks for your service the last couple of years. It's been pretty brutal on all you guys, doctors and nurses.
Thank you.
Thank you.
very much, Don.
Thank you.
Anyone else? Okay, Matt, I think you have something to say. Please step up. Do you swear to tell the truth, nothing but the truth, so help you God?
Yes, I do.
State your name and your address.
Matthew Carr, 272 Royal Avenue, Flanders, New York. And it hurts me that I've hurt so many people, and it's not my intent. I'm trying to run a business. And we had the cops there 16 times this year, and every time the cops came, they said that we were not in violation of the noise. We did have someone with a noise meter, And we did find out in September, that when they went to Bonnie's house, Schmidt's house, that we were in violation, okay? Because we had a decibel reader, and I guess where we were sitting wasn't the right spot. When the code enforcer went to a backyard, we were over. So instead of like us getting a citation, like maybe someone being nice to us, they just try to shut us down right away. We didn't get a chance to try to fix the problem. So that week, we hired sound consultants, and we're in the process now of, since we don't have a building, although we'd like to have one, we are in the process now of having a sound person design so that the noise will not go out and affect these people that's affecting them. So I'm trying to do the best I can. I do know, like Mr. Skinner, he called me and I spoke to him a few times. He is far enough away that we're never above the decibel limit that's allowed by the town. We're always below it. However, you can hear that there's music going on. So, I mean, that's the town code says we're allowed to be here, and that's where we are. At the Schmidt's house, we were over. So we're trying to work on that by mitigating the sound. We hired sound engineers right away. So it's not like I'm not whatever. And, you know, we have a valet parking. People saying, you know, do you have the key fob and all this different stuff? I mean, they're just piling on to what is basically, yeah, we have a little bit of a noise problem, which we're going to take care of. We're trying to take care of. That's all I have to say. I mean, I've been trying to get this for a long time. My lawyer tells me this is already something that you guys, or the town already, fought for us. And now you're trying to take back what you said all those years ago. I mean, we've been trying for so long to get something approved, and I understand people don't want it, but just like they have a right to their property, I think we have a right to our property. And you guys, how many years we've been doing this? I always said I'll do anything. When they say, oh, he's going to put a tent up, no, there's law. I can only do what I'm allowed to do. If I start to put tents up on the property, if you give me a barn, or I have the noise outside of people outside, you can shut me down. Just like I told Albie Schmidt. I said, you win, I lose. If I don't take care of the noise, I lose. So that's why I went and hired a sound consultant. But everybody wants to make me like I'm this bad guy, just freaking whatever. I started the Country Kitchen 37 years ago. I've been in this town a long time too, working very hard. And I told you 13 years ago it was a family business my son was going to take over, and that's happening. And shouldn't I be proud and happy as a dad? Yeah, I am. But, you know, I just need to be told what to do, which I'm trying to. We're trying to do the noise thing. We're trying to do some things that will help the problem, not just get the hell out of here.
Excuse me, Mark,
Yes.
how many weddings did you have in?
Oh, so that's right, 80 weddings last year? No, we had, I think, 32 or 33. And it was because of COVID. You know, we had twice as many jobs because we didn't have any the year before.
How big are the wedding parties?
They could be anywhere from 80 to 200. And yeah, we do have all the tents and everything because you have to make it weatherproof. So yeah, you know, we add the tents so it makes it more weatherproof. But if we had a barn, it wouldn't be the issue. And like I said, I still have to go by all the laws. If it's still noise, I have my doors open, I have tents outside. I mean, that's what laws are for. So I just can't. Then people say you can build a barn and do whatever you want. That's not true. You still have to go by the town, whatever they tell you, and all the laws and the codes. It's not like a freebie to have a barn. You can still shut me down then too if I don't do the right thing, right?
We won't shut you down. Do you have a permit for the tent that you use?
Yes, we get permits every year. For the last 5 years, I got 10 permits. All of a sudden, it's not any good anymore. For 5 years, I got 10 permits. Now all of a sudden, I shouldn't get a tent permit anymore? Why? I mean, I haven't done anything wrong. I'm just conducting my business. We have all the permits. Thank you very much.
Is there anyone else to be heard on this matter?
Mr. Chairman, might I ask if the board has taken any steps to acquire the record of what was before the board up to 2009? Do you have that record?
We'll have to check. I'm pretty sure we have everything.
I will tell you that what I looked at was the return prepared by council for the Article 78, and it appears to have everything in it. So if...
We have our homework to do.
I actually got it from Mr. Kosakevich when he was still town attorney, so he has it.
Okay. All right, so I move the appeal of Carr McVeigh LLC 370.
What about the Zoom people? Are there Zoom people for this?
Excuse me, I forgot all about those people. Anyone else to be heard on this matter? And again, if you have anything to add to it, great. If not, we'll just take your name and your address.
People are free to unmute themselves.
Yeah, you're free to unmute yourself, so step up to the plate. Thank you very much, by the way.
Nobody.
Anyone? Okay. If you just kindly raise your right hand, do you swear to tell the truth, nothing but the truth, so help you God?
I do.
State your name and your address.
James Durenz, 41 Peacock Path, Jamesport, New York. I'm the president of the Greater Jamesport Civic Association, and I've been approached by many of our members over the last year or two regarding this establishment, as well as others in our community, with the same complaints that you've heard here tonight. What I'd like to point out to the zoning board, and perhaps it's already known by the zoning board, but maybe not to the general public, is that the town of Riverhead has commenced litigation against the applicant that's now pending in Supreme Court for a declaratory relief as well as punitive damages. And the town of Riverhead itself has described the applicant as a public nuisance. And without getting into details, those submissions by the town of Riverhead contain affidavits from Riverhead employees who've investigated the complaints of the surrounding neighbors and have determined that on occasion, the decibel level and the timing of the music or the noise has exceeded the town's limits. And if I could, I'd like to just add that as the president of the Civic Association, not only on this instance with the noise level, but with other concerns in the town, it seems as if the town, while they're ready to implement or enact legislation or regulations, are lax to the extreme in enforcing them. So in this instance, I don't think the Zoning Board of Appeals can limit their inquiry into this applicant by just saying, oh, it's going to be a tent or a barn, without recognizing, and I think Mr. Skinner mentioned it, the obvious concern that such facilities, a tent, a barn, will be the source of noise, music, that will affect the surrounding neighbors. I just want to add one more thing, and that the lawsuit that is brought by the town of Riverhead is not only seeking injunctive relief against the applicant, but also monetary damages, $75,000.
Mr. Durenz,
So,
Mr. Durenz.
so I don't think the
Hold on one
applicant
second.
has
Hold on,
clean
Mr.
hands
Durenz.
in this instance.
Hold on.
Mr. Durenz, you realize the purpose of this hearing tonight is, it's limited in scope. We're here just to talk.
Well, that's your
about-
determination. That's not the determination of the community. It's
Sir,
not the
sir, just
determination
understand
of
each
our
other.
members.
Sir,
It's not the
Mr.
determination of
Durenz,
the
it's
neighbors.
not my determination. Justice Fornetti has made that determination.
And Judge Santorelli of the Supreme Court is going to rule on your town's application for injunctive relief and monetary damages against this applicant.
That's
And
not
I
before
think
us
the town
tonight.
board
It's not
should take
before
that
us.
into
It's not before
consideration.
us. It's not before us tonight.
Well,
Respectfully,
you should do a little investigation into it to see what the impact is going to be on the neighbors. And you should also realize what the town attorney is doing in this instance. You can't
all respect
just
to you, Mr.
just
Durenz.
close yourself off to it.
Mr. Durenz, with all respect to you, we are directed to solely for the purposes of determining whether it has to be a special permit. The other issues regarding noise, as much as I sympathize with you, that's not before us.
and you should educate yourself as to what your town attorney is doing in this matter regarding this applicant. And use that as a factor to consider their request for a special permit. That's my point.
No, you made your point.
Thank you.
Thank you.
Anyone else to be heard? Unmute yourself. Speak up. Nobody else?
Oh, yeah.
I'm not involved in this, but just sitting here, I can't help but to make one comment that would maybe be for Matt, that there are really a lot of resources out there.
You have to get sworn in. You have to get sworn in.
Oh,
So just,
You want to step up? It's painless.
You're going to
I'm
be
not
on,
gonna lie, I'm just gonna make a suggestion to the.
You want to raise your right hand, please?
you swear to tell the truth, nothing but the truth, so help you God.
Always.
State your name and,
He's recused.
state your name and your address.
Nadine Lafredo, I'm here for a different case. But
Was
as
it in
far as
there?
Matt and the noise abatement,
it was.
it's not enough to bring the decimal
bring that
point down. That you may have to construct things like they do on the roads, like the Gambian walls.
Okay.
Oh, the barriers, you mean? You mean those
Yeah,
barriers?
barriers to control, that's all. Someone should say a solution for him.
But again, you realize, we're not here about the
I
noise.
know, but he needs a solution.
Yeah, okay. Okay, is there anyone else on Zoom that would like to speak?
we're going to reserve decision, right?
I got it right here. There's nobody else to be heard? One last shot.
It's gone.
Okay. Now it's my turn.
Mr. Zaweski is recused.
Okay. First off, Mr. Zaweski has recused himself
And
from
not
this,
present.
from this matter, without prejudice. Okay. Appeal number 0929. I move the appeal of Carr McVeigh LLC, 370 Manor Lane, Jamesport, and it's map number 647-23, APZ zoning. Public hearing pursuant to the order of the Supreme Court of the State of New York dated April 2nd, 2013, that remanded the matter to the Zoning Board of Appeals for a new hearing and interpretation of the letter dated April 8th, 2008, made by Richard Hanley, Planning Director, regarding the addition or use of temporary temp on the property, and to review the Planning Director, Richard Hanley's letter dated January 16, 2009, regarding the applicant's second site plan application to locate the barn on the property upon the same grounds as set forth in the April 8, 2008 letter, to be closed and left for open written comment for 10 days. Reserved decision will be following the next meeting, at the next meeting.
So moved, Mr. Chairman.
Second.
All right, Mr. Barnes,
Leroy?
Aye.
Mr. Whitmire,
Aye.
Mr. Gazillo.
Aye.
And I vote aye. So we'll see you
Thank you.
folks the next meeting if you'd like to attend. Otherwise, it'll be on the, what? Be on the town,
Thank you.
yeah. Okay,
Good night.
yeah. So we're gonna take a 5-minute break. Go ahead, we'll talk.
Date of the next meeting, please?
Oh, that would help.
All right, so we said
Next meeting is April 14th.
April 14th.